Hi, my name is Elizabeth Well, and I'm the legal director at Ohio Crime Victim Justice Center. We know a lot is going on in the world right now, but don't forget that victims in Ohio have rights throughout the criminal justice process. The Ohio Constitution and Ohio Revised Code provide victims with numerous rights. While we're covering some of the most critical rights today, victims have many more rights. If you'd like to learn about all of the rights that victims have in Ohio, please visit the Victims' Rights Toolkit at www.victimsrightstoolkit.org. In order to qualify for rights in Ohio, victims must meet the definition of victim. In the Ohio Constitution, victim is defined as the person against whom a criminal offense or delinquent act was committed, and any person who is directly and proximately harmed by a criminal offense or delinquent act. This means that adults can be victims and children can be victims. It also means that adults can be offenders and children can be offenders. Victims of juvenile offenders have the same rights as victims of adult offenders, and child victims have the same rights as adult victims. In fact, in some instances, child victims may have more rights than adult victims. In addition to that, victims who are directly and proximately harmed by a criminal offense or delinquent act may include the parents of child victims, surviving family members of homicide victims, and anyone who witnesses a violent crime. All of these people may qualify for victims' rights in Ohio. Marsy's Law's implementing legislation has now been introduced in House Bill 610. These new laws will provide the procedures necessary to implement the Marsy's Law constitutional amendment and guarantee that all victims' rights are protected in the criminal justice process. Now that we've talked about who qualifies as a victim in Ohio, let's talk about the rights that a victim has.
Hi everyone, my name is Chris Woeste, and I'm the Deputy Legal Director at Ohio Crime Victim Justice Center. We know a lot is going on in the world right now, but don't forget that victims in Ohio have the right to notice of their rights. The Ohio Constitution guarantees victims the right to be notified of their rights. Victims in Ohio have many rights set forth in the Ohio Constitution, Ohio Revised Code, and in many other places. However, most victims have no idea that they have these rights. If victims don't know they have rights, how can they protect these rights? The Ohio Constitution and Ohio Revised Code provide victims the right to be notified of their rights at first contact with law enforcement and first contact with prosecutors. This early notice is crucial to ensure that victims have a meaningful opportunity to exercise their rights. If victims aren't provided notice of their rights and subsequently don't request notice of proceedings because they weren't aware of the requirement to make the request, an attorney could ask the court for a do-over of that hearing since the victim did not have a meaningful chance to exercise their rights. This could happen at various stages, but one example in the early stage is at arraignment. A victim or victim's rights attorney could file a motion requesting a do-over to be heard regarding safety, concerns, and bond conditions. During the COVID-19 pandemic, it is more important than ever that victims are made aware of their rights. As our courts begin to reopen, many courts, prosecutors, and defense attorneys will be operating on expedited timelines. By making sure that victims know about their rights now, we provide victims an opportunity to take the steps necessary to ensure that their rights are protected when court hearings resume. The Marsy's Law implementing legislation will provide that victims are not only notified of their rights, but are able to choose which rights to exercise at first contact with law enforcement and again at first contact with prosecutors by using the Victims' Rights Request Form. The form will follow the victim throughout the case so that everyone in the criminal justice system will know which rights the victim wants to exercise.
Hi everyone, my name is Diva Edel, and I am an attorney at the Ohio Crime Victim Justice Center. We know a lot is going on in the world right now, but don't forget that victims in Ohio have the right to privacy. The Ohio Constitution guarantees victims the right to be treated with fairness and respect for their privacy, and the right to refuse offenders' discovery requests, deposition requests, and interview requests. Offenders often try to obtain private victim information during criminal cases. such as victim medical records, counseling records, emails, and private communications, and even access to victims' phones and computers. Victims have the right to say no when defendants try to obtain their private information. When offenders seek to interview or depose victims, victims have the right to say no. I have helped many victims protect their privacy by filing motions to quash defense requests for private information, such as victim medical records, counseling records, computers, and cell phones. Through these successful motions, I have kept private information out of criminal cases and out of the hands of offenders. During the COVID-19 pandemic, if prosecutors or victim advocates are aware of any defense requests for private information, they should let victims know about these requests now so victims can obtain counsel, like myself or one of the other attorneys at Ohio Crime Victim Justice Center, to help protect their right to privacy. Courts considering live streaming trials or other hearings must allow victims' images and voices to be redacted from live streams and protect victims' identities with pseudonyms. The Marsy's Law implementing legislation will clarify the privacy rights of crime victims, such as the explicit right to have public records redacted to remove any information that would identify the victim.
Hi everyone, my name is Brianna Schultz and I'm a victims' rights advocate at the Ohio Crime Victim Justice Center. We know a lot is going on in the world right now, but don't forget that victims in Ohio have the rights to safety and protection. The Ohio Constitution guarantees victims the right to be treated with fairness and respect regarding their safety. It also guarantees victims reasonable protection from the accused or anyone acting on behalf of the accused. Offenders may try to intimidate or threaten victims to persuade them to ask the prosecutor to drop the charges, to stop pursuing a protection order, or to otherwise stop seeking justice in their case. The rights to safety and reasonable protection can include many things, such as the presumption of arrest in domestic violence cases, the ability of the victim to seek a protection order, and appropriate remedies when a victim or any other witness in a criminal case is threatened, harassed, or intimidated by the accused or anyone acting on behalf of the accused. Our attorneys have protected victims' rights to safety and protection by filing motions to revoke bond when offenders violate the terms of their pretrial release, and by filing motions opposing early release for offenders. During the COVID-19 pandemic, it is extremely important that law enforcement continue to protect victims of violent crimes by arresting offenders and serving protection orders. Without these crucial protections, victims can be especially vulnerable during this time. The Marsy's Law implementing legislation will clarify the safety and protection rights of crime victims, like the right to notice of arraignments, so that victims can attend proceedings and share their concerns regarding the release and the bond terms of their offenders.
Hi everyone, my name is Sierra Davis, and I'm a victims' rights advocate at Ohio Crime Victim Justice Center. We know a lot is going on in the world right now, but don't forget that victims in Ohio have the right to notice of release or escape of their offenders. The Ohio Constitution guarantees victims the rights to notice, upon request, of any release or escape of their offenders. Whether an offender is being held in a local jail or detention prior to trial, or an offender has been convicted of a crime and is incarcerated, the Ohio Constitution and Ohio Revised Code provide that a victim has the right to notice of any release of the offender. In some cases, the victim may need to request notice, but in the case of many offenders in prison, the victim may receive these notices automatically. If courts and custodial agencies release offenders early without providing victims with notice and the opportunity to be heard, the attorneys in our office can help victims by filing motions asking courts to reconsider the release and redo the hearing to allow the victim to be present and heard. During the COVID-19 pandemic, many courts and custodial agencies are releasing offenders to reduce the spread of the virus. It is very important that victims receive timely notifications of any release of an offender. Most releases legally require a hearing in advance of release. In this case, victims should be given notice and the opportunity to be heard. The Marsy's Law implementing legislation will address the expanded notice rights provided to crime victims under the Ohio Constitution. Such rights to notice of post-conviction hearings, like expungement hearings, record sealing hearings, and pardons.
Hi everyone, my name is Jessica Combs, and I am a member of the Survivor Advisory Panel at Ohio Crime Victim Justice Center. We know a lot is going on in the world right now, but don't forget that victims in Ohio have the right to notice of public proceedings upon request. The Ohio Constitution guarantees victims' right to notice upon request of any public proceeding. While the Constitution and the Ohio Revised Code only require notice of public proceedings to be provided to victims who request notice, many prosecutors provide these notices automatically. Notice of proceedings is extremely important because many other victims' rights are dependent upon victims receiving meaningful notice. My case began a few years ago when a car full of people hunted down my teenage son and his friends as they were fleeing for safety, and one of them shot and senselessly murdered my son as he drove away to save himself and his friends. There were multiple co-defendants in both juvenile and adult courts, and it was important for me to exercise my rights. I wanted to be present for every court proceeding and be heard whenever I had the right to be heard. To do that, I needed meaningful notice to prepare. Around the 1-year anniversary of my son's death, I got a call in the evening that a hearing was set for the first thing in the morning of the next business day to potentially release 2 of the juvenile offenders responsible for my son's death. This short notice was not enough time for me to be able to meaningfully exercise my rights. Marsy's Law and the implementing legislation would have allowed me the chance to reopen the hearing to have a meaningful right to be heard regarding their release. During the COVID-19 pandemic, many courts and custodial agencies are considering expedited hearings to ensure that speedy trial rights are preserved and dockets are not clogged. However, notice of proceedings must still be provided to victims upon request with reasonable and timely notice to exercise their rights. The Marsy's Law implementing legislation will establish minimum timeframes for notice to be considered effective.
Hi everyone, my name is Cory, and I am a volunteer at Ohio Crime Victim Justice Center. We know a lot is going on in the world right now, but don't forget that victims in Ohio have the right to language access and assistive technology. The Ohio Supreme Court rules of superintendents and federal law guarantee victims the right to language access and assistive technology so they can participate in the criminal justice process. Victims cannot effectively exercise their rights if they are unable to communicate with criminal justice system officials and allied professionals. The law guarantees victims access to interpreters and assistive technology to ensure that all crime victims have meaningful opportunities to exercise their rights. If a victim is being denied access to language access or use of assistive technology, the victim can contact us for free legal assistance. Our attorneys can file a motion invoking the victim's right to language access or use of assistive technology to help ensure the victim's rights to be informed, present, and heard are truly meaningful. During the COVID-19 pandemic, many courts had moved to virtual courtrooms, holding hearings through telephone or video conferencing software. The use of technology provides flexibility and enables many victims to assert their rights without having to choose between their physical health and their rights. However, victims who are non-English speaking, limited English proficient, deaf, deafblind, or hard of hearing may require accommodations to ensure access to virtual court proceedings. Many Ohio companies are providing virtual interpretation services. The Marsy's Law implementing legislation will further address crime victims in need of assistive technology, non-English speaking, limited English proficient, deaf, deafblind, or hard of hearing crime victims rights to interpretation services and effective communication.
Hi, everyone. My name is Bobbie Yeager, and I'm the Senior Staff Attorney at Ohio Crime Victim Justice Center. We know a lot is going on in the world right now, but don't forget that victims in Ohio have the right to be treated with dignity. The Ohio Constitution guarantees victims the right to be treated with fairness and respect for their dignity. This right can mean a lot of things. For instance, some child victims and victims with developmental disabilities have the right to seek to testify by a closed-circuit television or recorded deposition rather than in-person testimony. This right provides victims with a sense of comfort in knowing that they will not have to testify just a few feet away from their offender in a courtroom. For example, I previously represented a child victim in a particularly heinous case in which the child was brutally assaulted and left for dead by his offender. On top of his healing process, this brave young boy was worried about testifying. He was beyond terrified because he would have to walk past his offender just inches from his reach to enter the courtroom, take the stand, and testify. But he wanted to testify, to do everything that he could do to ensure his offender couldn't hurt anyone else ever again. As his attorney, I assisted with getting a court order allowing him to testify by closed-circuit television so he would not be re-traumatized while seeking justice. During the COVID-19 pandemic, many courts are conducting virtual hearings. Courts should consider expanding the right to seek alternatives to in-person testimony. Expansion of this right protects victims' physical health and mental well-being. Victims may exercise this right through the prosecutor, or if they prefer, they may obtain their own counsel, such as myself or another attorney at Ohio Crime Victim Justice Center, to help them exercise this right. The Marsy's Law implementing legislation will expand ages of children able to testify via closed-circuit television or recorded deposition, and will also provide additional accommodations for child witnesses and witnesses who are developmentally disabled.
Hi, everyone. My name is Leah Williams, and I am the Director of Advocacy at Ohio Crime Victim Justice Center. We know a lot is going on in the world right now, but don't forget that victims in Ohio have the right to be present at criminal justice proceedings. The Ohio Constitution guarantees victims the right to be present during all public proceedings and court dates during the criminal case. This right is important to victims who often want to see and be involved in the criminal justice process. A victim's right to be present has further support in both the Ohio Revised Code and the Rules of Evidence. Ohio allows victims to remain in the courtroom even when they will be a witness in the case. 8 of the 12 appellate districts in Ohio have upheld a victim's right to be present if the offender's right to a fair trial will not be violated. Our attorneys routinely file motions invoking victims' rights to be present at trial and other hearings. If a victim or victim's representative is being denied access to a hearing, being told they can't be present during a trial, or being excluded from any public proceeding, the victim can contact us to request free legal assistance. During the COVID-19 pandemic, if a victim, victim's representative, or support person is at risk of contracting COVID-19 or experiencing heightened anxiety due to concerns over COVID-19, the court should consider allowing victims and other participants to be present via alternative means, such as teleconferencing or video conferencing. The Marsy's Law implementing legislation will provide expanded guidance on the constitutional right to be present by, for example, requiring continuances when victims have invoked the right to notice and to be present and heard, but were not notified of the hearing.
Hi, my name is Chelsea Balhaj, and I'm the volunteer director here at Ohio Crime Victim Justice Center. We know a lot is going on in the world right now, but don't forget that victims in Ohio have the right to be heard. The Ohio Constitution guarantees victims the right to be heard at any public proceeding during the criminal justice process. The victims have the right to be heard in any public proceeding involving release, plea, sentencing, disposition, parole, or any other time a victim's right is implicated. A victim can exercise the right to be heard themselves, through a representative, or through the prosecutor in some circumstances. Courts allow victims to be heard in writing and or orally to take the victim's objections and arguments into consideration before making determinations in the case. Our attorneys routinely file motions invoking victims' rights to be heard regarding plea hearings and other matters that implicate victims' rights. If a victim or victim representative is denied the right to be heard by court when the rights are at stake, the victim can contact us to request free legal assistance. During the COVID pandemic, a victim's representative, or support person is at risk of contracting COVID-19 or experiencing heightened anxiety due to the concerns over COVID-19, the court should consider allowing victims and other participants to be heard via alternative means such as teleconferencing and video conferencing. The Marsy's Law implementing legislation will require courts to inquire whether or not a victim was informed of their right to be heard.
Hi everyone, my name is Alex Fehder, and I'm a victims' rights advocate at Ohio Crime Victim Justice Center. We know a lot is going on in the world right now, but don't forget that victims in Ohio have the right to confer with the prosecutor's office. The Ohio Constitution and the Ohio Revised Code guarantees victims the right to confer with the prosecutor. Specifically, the Constitution allows victims to confer with the prosecutor upon request, and the Revised Code states that the prosecutor must confer with the victim, if practical, at certain points in the criminal case, such as before a trial and before accepting a plea. The right to confer goes to the heart of victims' rights, which give victims a voice in the criminal justice process, but not a veto. This means that while the prosecutor must talk with victims about potential plea agreements prior to acceptance, the victim cannot override the prosecutor's decision. But studies show that providing victims a voice and consideration in the process also plays a crucial role in their healing process. Our attorneys often file motions invoking victims' rights to confer with prosecutors, especially when plea agreements are being discussed. If victims ask the prosecutor to confer with them, but the prosecutor refuses, our attorneys can file motions on behalf of victims expressing the victim's opinions about plea agreements or other matters in the case. If a court conducts a plea hearing or sentencing hearing, and a victim who has requested notice of the hearing has not been notified or not provided timely and reasonable notice, and thereby unable to exercise their rights to be present and heard, our attorneys can file a motion to reopen a plea or sentencing hearing to help ensure the victim's rights are being afforded. During the COVID-19 pandemic, many courts are expediting proceedings and conducting virtual proceedings. If a victim has chosen not to be present at the plea hearing, either in person or virtually, the court should verify on record that the prosecutor has discussed the plea agreement with the victim and also ask the prosecutor to share the victim's position. If the victim does want to attend the hearing, either in person or virtually, the victim must be provided sufficient notice, the option to be present via telephone or video conferencing, if applicable, and the opportunity to address the court regarding their thoughts on the plea agreement. The Marsy's Law implementing legislation will further address the victim's rights to be heard regarding plea agreements and to timely and reasonable notice.
Hi everyone, my name is Emma and I am a victim rights advocate at Ohio Crime Victim Justice Center. We know there's a lot going on in the world right now, but don't forget that victims in Ohio have the right to make a victim impact statement at sentencing. The Ohio Constitution guarantees victims the right to be heard in any public proceeding in which the rights are implicated, including sentencing. The Ohio Revised Code also provides victims with the right to give an impact statement at sentencing. A victim impact statement can inform the court of the victim's physical, emotional, and financial losses that resulted from the crime. A victim impact statement can be read aloud, submitted in writing, or both. The victim also has the right to provide impact evidence to the probation officer conducting the pre-sentence investigation. Victim impact statements allow victims to fully explain the harm the crime caused them and make sentencing recommendations. Victim impact statements are often very important to crime victims and, as studies have shown, can aid victims in their healing and recovery process. Our attorneys often file motions invoking victims' rights to make impact statements, and also can file sentencing briefs on victims' behalf. If victims are denied their rights to make an impact statement or are not provided reasonable and timely notice of a sentencing hearing after requesting notice, and as a result are unable to exercise their rights to be present and heard, we can help. In some cases, our attorneys can assist victims by filing a motion to reopening the sentencing hearing to help ensure the victim is given a chance to make an impact statement. During the COVID-19 pandemic, many courts are conducting virtual proceedings. If a sentencing is conducted virtually, victims must have the chance to provide a victim impact statement. Where cases continue due to COVID, prosecutors and advocates should encourage victims to begin thinking about a victim impact statement, as well as gathering evidence, such as bills and receipts, for restitution. The Marsy's Law will clarify that victims can provide victim impact statements both orally and in writing.
Hi, everyone. My name is Morgan Keilholz, and I'm a victims' rights attorney at Ohio Crime Victim Justice Center. We know there's a lot going on in the world right now, but don't forget, victims have the right to restitution. The Ohio Constitution guarantees victims full and timely restitution. Restitution is a monetary payment from the offender to the victim for economic loss suffered by the victim as a direct and proximate result of the offender's criminal offense or delinquent act. Restitution is typically addressed at the sentencing phase of the criminal justice system. Although the sentencing court is afforded some discretion in the amount of restitution awarded, the Ohio Constitution mandates that courts award restitution when presented with competent, credible evidence of a victim's losses. In a recent case, I provided no-cost legal representation to a victim to assert her right to restitution. Although the victim presented the court with competent, credible evidence of her economic losses, the trial court did not award restitution. On behalf of the victim, OCVJC filed a petition for a writ of mandamus. The 12th District Court of Appeals issued the writ, directing the trial court to reopen sentencing to allow the victim to assert her right to restitution. During the COVID-19 pandemic, if a victim is seeking constitutionally guaranteed full and timely restitution, the court should postpone the restitution hearing if the offender or the victim disagrees with the amount ordered. This will allow the victim more time to compile the necessary information to support a restitution award. The Marsy's Law implementing legislation will clarify the restitution recovery rights by expanding the definition of restitution to include future expenses related to a victim's economic loss, such as counseling, medical expenses, future lost wages, and other expenses that continue after a criminal case is over.
Hi everyone, my name is Meredith, and I'm a volunteer at Ohio Crime Victim Justice Center. We know a lot is going on in the world right now, but don't forget that victims in Ohio have rights and protection order proceedings too. The Ohio Revised Code guarantees victims the right to be accompanied by an advocate or support person during protection order proceedings. Often, the guidance and support of a victim advocate or other support person gives the victim the additional strength and assurance to seek out the protection they need. Without the guidance and support of an advocate, many victims may decide not to seek the protection they need. In addition, many organizations and law school legal clinics provide victims no-cost legal assistance with protection order hearings. If victims are denied a criminal protection order or are denied the ability to have an advocate or support person present while seeking a civil protection order, the victim can contact us. We can file motions in the criminal case requesting a criminal protection order for many victims. We can also help victims and advocates ensure their rights to be present during civil protection order hearings. During the COVID-19 pandemic, reports indicate that domestic violence, child abuse, and other interfamily violence is on the rise. Advocates have seen an escalation in the severity of violence in domestic violence and child abuse cases, with victims reporting to the hospital with serious physical injuries. When criminal proceedings have been postponed and victims are unable to take the preferred step of obtaining a criminal protection order from the court at arraignment, many victims will look to civil protection orders for the legal protection that would otherwise be provided in a criminal case. If courts are conducting proceedings virtually, both victims and victim advocates should have the opportunity to attend these proceedings virtually as well. Victims should keep in mind that civil protection order proceedings will involve testimony at hearings that defendants can use in the criminal case. For this reason, criminal protection orders are often the best option. The Marsy's Law implementing legislation will improve access to court proceedings and the information regarding the procedures and resources available for the protection of the victim, including protection orders.
Hi, my name is Kathy Harper Lee, and I'm the founder and executive director of Ohio Crime Victim Justice Center. Thank you so much for joining us. As you have just heard, the Marsy's Law constitutional amendment expanded the rights of crime victims. One of the most important aspects of the constitutional amendment is that it clarified that Ohio crime victims have the right to retain counsel and to seek appellate review if their rights are violated. Without this key provision, the rights provided in Marsy's Law and the Ohio Revised Code could be rendered meaningless. The Marsy's Law implementing legislation, House Bill 610, has now been introduced. House Bill 610 provides crime victims with the same appellate options provided to any person in Ohio who has a constitutional or statutory right. Specifically, it provides that crime victims can file an interlocutory appeal or a direct appeal after the conclusion of the case, or a complaint for an extraordinary writ. Each of these means to seek appellate review is different, and each may be applicable in different situations. Remember, crime victims have the right to retain an attorney. Although the state is not required to pay for the victim's attorney, victims should be told that they have the right to retain an attorney and provided information about organizations that can provide no-cost legal representation. If you are working with a victim of crime and have questions about whether or not their rights have been or are being violated, please call us. In addition to providing direct legal assistance to crime victims, our victims' rights attorneys are here to support advocates and allied professionals. Our victims' rights attorneys can provide no-cost legal advice and provide letters of opinion to further support your efforts. Please keep in mind that the rights we've shared today are only a handful of the many rights of victims in Ohio. For a complete list of victims' rights in chronological order by phase of the criminal justice process, please visit the Victims' Rights Toolkit website at victimsrightstoolkit.org. If you'd like additional training about victims' rights in Ohio, please visit our website at OCVJC.org and join us for scheduled webinars, which are approved for CLE and CEU credits. Thank you again for joining us. We hope that you stay safe and healthy during this difficult time and know that we are here to serve you and your clients.